Number 81, West Midtown Management Group versus State of New York. Counsel?
Good afternoon. May it please the court, Caroline Olson on behalf of the Office of the Medicaid Inspector General. With the court's permission, I'd like to reserve 2 minutes for rebuttal.
You may.
A final audit report found that West Midtown had received Medicaid overpayments of $1.86
Counsel, what's the
million.
exact issue before us? Are we here to determine whether the IG can recoup the entire amount by any means, or are we here to determine whether the overpayment can only be recouped through the withholding process as defined in the notices?
We're here to correct the error in the First Department's decision, which conflated and basically equated the force and effect of the final audit report with the notice of withholding. Under Social Services Law 145A, a final audit report has the effect of the final audit report here had the effect of a $1.86 million money judgment. That was the final and dispositive determination of liability. Under the relevant regulatory scheme, notices of withholding simply inform a provider that the agency has selected a particular mechanism to recover that. And so the First Department's decision confused liability and remedy, and that's the error that needs to be corrected.
Put another way then, did the First Department decision foreclose your agency from withholding, or did it prohibit you from collecting at all?
Well, on the very first page of the decision, it does say that under the final audit report, the agency is limited to, under the final audit report, to collecting $1.46 million, to $1.46
So they've limited the amount of your recovery.
Well, I think that we would need clarity from the court that the order does not limit our recovery under the final audit report.
So when it comes to the withholding part of it, do you agree that the notices that you sent that are in the record were not sufficient to enable you to collect that additional amount without some further notice at least?
Well, I don't think that issue...
Not to collect, I'm sorry, to withhold.
I don't think that issue is squarely before the court because, again, in this instance, the agency did issue additional notices of withholding before it began collecting the remainder of the $400,000.
And this lawsuit was actually commenced before those notices, the subsequent notices went out, right?
That's exactly right, yes.
So those notices aren't necessarily part of this record, so that's why it's not before us, or?
I think under this court's case law, including Michael B., the court should consider, can very well consider those, and I think it's particularly appropriate to do so here because the main contention is there was a lack of notice, but in fact the agency provided the notice that everyone seems to, that the petitioner.
Isn't that the point? Isn't the point you provided a right to recover? The question is, does that eliminate the fair notice requirement that's set out in 519.5, and that's a distinction that it seems that the appellate division drew here.
Well, I think there are to unpack that question a little bit. I think the question is notice of what, and so the final audit report puts the agent.
Well, the notice of the amount that you're going to collect. That's what you're required to give. That's what a fair notice requirement would be, and you can't conflate the two things. The right to recover is not the same as the right to notice of a party of what you're going to recover. There's no question you properly established the right to recover here. Just a question of whether or not they were properly notified of it. And the way I read what the appellate division said is that, yeah, you got a right to recover, but you still have to give them the notice of the amount that you're going to take.
And I think the notices at issue here did do so. If you read the notices, they have to be read in light of the statutory and regulatory context, and they have to be read in light of the fact that the notices, which are on page 50 of the record, explicitly reference the final audit report. That portion of the final audit report says that if you do not settle within 20 days, the agency will begin to recover. Will provide notice, will begin to recover, not barring any other remedy at law. But even if, putting aside the plain reading of the notices, we know that West Midtown understood that the final the final audit report was its statement of liability, and that the notices of withholding did not affect that. And we know that because there are 3 contemporaneous statements in the record from West Midtown that post-date the notices that use the $1.46 million figure that say we understand that we are liable for $1.86 million. And so there really can be no question that they actually understood that point.
Have you by now withheld the full amount, the 1.86?
That's correct. Following the issuance of the notice in July 2014, the agency did collect that amount. And so what this action is really trying to argue is that we were somehow precluded from issuing additional notices of withholding, and that money has to be, that money, which no one disputes is an overpayment for services that were not reimbursable under Medicaid, have to be, nonetheless have to go back to the provider.
And did you collect those under the notice the newer notice that's not in the record, or did you collect them under the old notice, or is it not clear what notice you collected it under?
Those were collected exclusively under the subsequent notices, the first one being issued in July 2014. And just to remind the court about why there was this what's seemingly a gap, at West Midtown's request, the agency granted a significant reduction in the withholding rate from 50% to 5%. So it actually took several years to recover the full $1.46 million. When the agency had recovered that in mid-2014, the agency then expeditiously provided notice that it was going to collect the remaining amount.
The thing that's stumping me a little, that I'm probably just missing something, is if what's at issue here is whether the notices that are in the record gave you the ability to collect beyond the 1.46 million, but in fact you withheld the difference between the 1.46 and the 1.86 based on notices that aren't in the record, sort of what we're doing here. Because even if we say you could or could not collect that additional amount under the original notices, you didn't actually collect it under those notices.
Well, again, that gets back to the sort of the reason why we're here to begin with, which is that the first department's decision actually treats the notices of withholding as if they can amend the final audit report and the liability.
So that's the sole point.
So the issue really is, did that FAR, I'm calling it a FAR, that final audit report, get amended by those notices? And your position is it doesn't because they didn't accept any offer of settlement within 20 days.
Our position is that the notices of withholding could not amend the final audit report, and that is true because of the statutory and regulatory scheme under the social services law, and it is also true as just as a matter of fact here that the notices of withholding, when plainly read, could not be read to somehow limit the liability, and that, again, is confirmed from those contemporary statements.
Just so I'm clear, and maybe I read the record wrong, is the actual notice, not the FAR, but the notices that were sent out said 1.4, right?
That is correct, but the
Okay,
very...
so let me just follow up. So they said 1.4. The only time that they got actual notice of the 1.8 was on a telephone call. Is that correct? Because that's what the record says.
I think that's incorrect because I think the final audit report provided notice that they were on the hook for 1.86.
Well, it didn't provide the statutory notice that's set out in 519.5, did it?
I think there's an open question whether it is sufficient to put the notice of withholding into the final audit report, but here, the final audit report did do that, and I would just say on the September 2013 call, two of the 3 contemporaneous statements from West Midtown in correspondence with the court and the agency acknowledged the 1.86 million. So between the notice of withholding that mentioned 1.46 billion and that September call, they acknowledged their liability for 1.86
So
billion.
could you help me with one more thing? There's a sentence in the appellate division sentence, the majority, that says, contrary to the dissent's assertions, we express no view as to OMIG's right to continue pursuing the higher point estimate. What does that mean?
It's a somewhat bewildering statement in the decision. Again, I point to the court to the fact that in that beginning part of the decision, the court said that the agency was bound or was capped at 1.46 million. But I think regardless of how you read that sentence, we're seeking clarity that the notices withholding and that were not capped to the final audit report and that the agency was free to collect the 1.86 million.
Thank you, counsel. Counsel?
What does that sentence mean?
Well, I can only speculate, Your Honor, and I'm perfectly willing to do that. First, if it may please the court, I'm Jonathan Goydell, and I'm here on behalf of the respondents. I don't know whether or not what the appellate division majority meant by that was perhaps there is some other vehicle by which, perhaps another audit, perhaps some other vehicle by which they could seek to pursue the higher number. I don't know, but what I do know is that, as Justice Fay said a couple of times, the requisite notice was not given for withholding more than 1.4, and if I could get
But does that, isn't there more than, first of all, isn't there more than one way to collect the liability
that's
owed?
Your Honor, yes.
Okay.
And
Well, let me finish.
Surely.
So withholding is one way.
Correct.
Okay, and let's assume for the moment that up until the time they collected the $1.4 million, right, they had only served notices of their intent to withhold that amount. What prevents them from then serving additional notices of withholding of the amount between 1.4 and 1.8 million dollars?
the statutory framework requires that they give particular notices of what they are going to do, how they're going to collect the amount that they've determined to collect.
But does it say they have to do it at the very beginning and never change?
And never change.
Never change the method or the amount that they do by any particular method?
Well, Your Honor, that's an interesting question, and I suppose that requires a looking into, as I've done in preparation for arguing here today, into the definition of not barring any other remedy permitted by law. And I would suggest to the court that increasing the amount that you're collecting is not a remedy. I think that sentence contemplates attachment. I think it contemplates the filing of a judgment. I think it contemplates cutting off their rights as a
But
provider.
are those things exclusive? Why couldn't they have, these look like form notices to me, by the way. So they have their form notices for withholding the lower amount, and then they can move on and try and collect all the way to the top if you do not appeal it, if you don't seek administrative review.
Because what the notices say, the cover letter, which is statutorily required or required by regulation, contemplates three scenarios. So the provider is given notice of three potential scenarios, not the fourth, which is what the OMIG is now suggesting was an available option. Three. Option number one, pay the entire 1.4 immediately. Write a check, here you go, we're done.
Within 20 days, yeah.
Yes, within 20 days, correct. Option number two, contact us within 20 days and work out a payment arrangement for that money, and you get to control your fate in terms of controlling your cash flow. This is a business, controlling the severity of the effect of the withhold on your business. And then option number three, which is in the last paragraph of the first page on page 37 of the record, is if you do nothing, which for all intents and purposes, I suppose, is what my client did. If you do nothing within that period of time, we're going to collect 1.4, but we're going to do it at 50%, and that's a heavy lift.
No, it said we're going to withhold 1.4. It didn't say that's
gonna collect.
all we're going to collect.
It says we're going to liquidate.
No, it says, yeah, we're going to withhold equal to 50% of your medical billings to recover payment and liquidate the lower confidence limit amount, interest and/or penalty.
Right.
Not barring any other remedy allowed by law.
So now the question is, what is any other remedy allowed by law? And I think, and the majority of the appellate
But
division...
think of it logically, sir.
That's what I'm trying to...
They've got this lower amount that they say we have a very high confidence level that even if you appealed, we will succeed. You're going to have to pay this. Then we believe there's an additional amount over that, and they give you what that top number is.
Right.
We have a confidence level in that. Depends if we're going to win that, fine. But all this says is, look, pay the whole, as you say, pay the whole amount, or work upfront, or work out a payment schedule. Logically, you're saying that they are then giving up the other amount if you do nothing?
Well, what I'm saying is that if you then
Why
take...
is government giving up all that money?
Well, they're not. What they're doing is, what they say in that notice, in the cover letter, they say, we will pursue the 1.8 if you appeal. So the notices that they give are not bereft of reference to the 1.8. They could easily.
Well, they're telling you what will happen if you go through an appeals process.
But they don't tell you what
But if you
will-
do none of these
They
things,
don't
you're
tell you-
liable.
No, they don't tell you that. What they tell you is that we're going to liquidate
But
your.
isn't that I think the question is, isn't that the only logical assumption? Because the result that you're arguing for would say, here are all these options, okay? And this would be the higher amount and this would be the lower amount. And then if you do nothing, you automatically get the lower amount?
At 50%. It's not that you automatically get it. Yeah, the options contemplate your participation by negotiating, which, by the way, they did.
Yeah, but
They
then
did
your
contact within
client
20
came back.
days.
Yes, but your client came back to the well and didn't want 50%. You got it down to 5%.
Well, that's-
So in actuality, this paragraph doesn't really apply the way you're suggesting it does.
Well, except that in theory, there are no paragraphs because we did contact within 20 days. And we did say a 50% withhold is going to destroy our business, you're going to put us out of business. We did. And we've always taken the position, and the IG said that we seem to have abandoned it. It's not that we abandoned it, it's just that there's no.
So I'm sorry, you're saying you complied with option 2?
And indeed, we did. We contacted within 20 days, and there's in the record multiple letters and emails to the Office of the Medicaid Inspector General saying 50% is going to kill us. It's going to kill my client, put him out of business. Please reduce to 15%. Here is the information that you've requested.
And was that with reference to the 1.4 or the 1.8?
They believed it was within reference to the 1.4. That's the point, because that's the only
Well,
amount.
weren't you still talking about the 1.8?
But they were, no, there was no reference to the 1.8. There was only reference, they said they were going to liquidate the 1.4 at 50%. And O'Connell and Aronowitz said, please don't do that. Please liquidate the 1.4 at 15%. And here are the financial documents for that. What seems to be the fly in the ointment to making this a nice, smooth matter is that my client contemplated through counsel appealing, but they never did. So the OMIG is attempting to treat this as a situation where they did appeal because they expressed an intention to appeal.
That's not how I interpret it as them saying that they did not, that your client did
But they
nothing.
didn't do
But
nothing.
aren't you really sort of making an estoppel argument?
I don't believe so. I believe that, as Judge Fahey said, what we're doing is we're saying there's a statutory framework and you have to give requisite notice. And they wouldn't.
But notice of what?
Noti-
So the FAR, the right final audit report, gave notice. Okay, this is the amount we think you owe, 1.8, but this is the amount that we're willing to negotiate with you about the 1.4 if you do certain things. Okay, and then assuming that you don't do those certain things, then they say we're going to immediately start to withhold money.
At 50%, but they did contact him. It's that
Correct.
last paragraph on page 37 that says, if within 20 days you fail to make full payment or contact the OMIG, which they did. Now, there is
No, and arrive at a plan.
No, that's not what it says with regard to the last paragraph. It does not say that. But in any event, they did come to a plan, and we've always taken the position that there really was an agreement reached and that it was done through various conversations and meetings. OASIS, the Office of Alcohol Substance Abuse Services, was involved. They were lobbying on behalf of my client with the sister agency, and there was ultimately an agreement that it was going to be 1.4. It's not in the record because it was oral.
Has any lower court agreed with you about this option 2, that you did actually comply with the requirements?
Well, yeah, they mentioned that we did contact within 20 days and that it's not true that we didn't. Yes, of course.
Who's the "they" in that sentence? When you said that they, I asked what court has found that. You
Oh,
said they.
I'm
Who's the
sorry.
they?
Yes, the appellate division did in fact acknowledge that within 20 days there was contact made, and it's in the record. It's plain.
But did they determine that that contact complied with option number 2?
There was no discussion of that specifically, but it was. And if I could just, Your Honor asked, why are we here if they've already collected it and it was under the separate notices? Nobody's done the math, and it's not before the court. But if they were collecting 1.4 versus 1.8 at interest, then they would have had to be, a lot of more of that money would have been going toward interest. And they would not have actually satisfied the notice requirements because they would have started collecting, it still would have been principal versus interest that they were collecting under the original notices. So those numbers don't jibe.
Thank you, counsel.
Thank you.
Counsel?
Did they comply with option 2?
No, they didn't, Your Honor.
Why not?
Because in order to comply with option 2, there had to be a settlement agreement. You had to enter into an explicit repayment agreement to reach the 1.46 million. Everything in the record actually defies the idea that there was some kind of settlement reached. Not only was there the July 2nd email that said, we expect to request a hearing, but after they defaulted on their right to request a hearing, they brought litigation to overcome that failure and to actually try to reduce the liability determination in the FAR. And so
So in option 2, this reference to repayment agreement is defined somewhere else as a formal written agreement?
it's not, but I think the common sense reading of this of the FAR, the cover letter combined with the provider rights section is, you're liable.
Let me ask you something. So let's say I'm the target. I call up day 18, and I say, yes, I want to, we'll pay the lower confidence amount. I can't do it at that rate. Can you work with me? I'll do it in the following way. And if you all at that point over the phone agree, is that a repayment agreement?
I don't think that, respectfully, I don't think that's the facts that we have here. I think
No,
it's
but
in
I'm
fact-
asking, would that be?
It could be. I think that it would probably have to be memorialized somewhere, and it was clearly not memorialized on this record. I would just like to say to the petitioner's trying to argue that these notices of withholding and trying to characterize them as if they said, the agency is collecting 1.46 million and no more. And there's no support in the record anywhere for that contention. They expressly refer back to the final audit report, which says that if you default if you do not accept a settlement, we will begin within 20 days to withhold, not barring any other remedy at law. I think they're trying to manufacture confusion out of the cover letter here, but this is an ex post reading, whereas we have contemporaneous statements from West Midtown demonstrating that throughout the course of the litigation, they understood that they were on the hook for $1.86 million. And for all of these reasons, we ask the court to reverse the First Department's decision, holding that the notices of withholding had the effect of altering West Midtown's liability, and that the agency was permitted to recoup the full $1.86 million over payments.
Thank you, counsel.